are live. Let me start the counter. Alrighty. Good evening.
Good
Hi,
evening.
Mila. Hi, how are
Hi,
you?
I'm well, thank you. How are you?
Thank you. I'm good. I'm doing very well. Thank you for asking. Thank you, everyone who has been able to join us this evening. We will just jump right into it. Welcome to Safe Space. My name is Noeline Mumbi. I am a supply chain professional and the Safe Space curator. Safe Space is a safe and open forum for learning and discussions and knowledge transfer across multiple industries. It's not industry specific, it is for everyone. This is a judgment free space where members and audiences can freely ask questions and propose topics, fostering a supportive environment for personal growth and knowledge sharing. The commitment here is for inclusivity, ensuring that everybody feels respected, valued, and this is a space that is free from any form of judgment and discrimination. Today, we will be speaking on the topic of employment law, your rights and obligations, what you need to know. I am joined by Mellap Wataka. I want to pronounce your name very, very correctly before I remix your name. All right. So to introduce, sorry about that. Let me remove this and introduce you, Millap. So introducing Millap. Millap is oh my goodness, just a second. Millap is a litigation and dispute resolution lawyer practicing in Nairobi, Kenya. Millap is an advocate of the High Court of Kenya. She graduated with a Master's of Law from King's College London and a Bachelor of Law from the University of Nairobi. Millap has extensive experience in advising and acting for both local and multinational clients in complex commercial disputes in various sectors across the economy. These sectors include banking, hospitality, telecommunications, insurance, private equity, agriculture, real estate, and many, many more. Milap has successfully represented clients across all levels of the courts, and her recent experience includes obtaining orders in favor of clients in both the High Court and the Court of Appeal. Milap's robust skill set in dispute resolution also includes successfully representing clients in arbitration and mediation processes. Milap has a wealth of experience in employment law and has successfully advised and acted for several clients on a variety of employment issues, including handling C-suite separations, representing clients in employment disputes, advising on redundancy and retirement processes, among many others. She has widely published insights on developments in employment law and conducted several trainings for multiple organizations on employment law and processes in Kenya. Milap's professional contribution on legal insights has been widely recognized through her engagement with her wide online community, and she has been republished by international publications. She was also recognized as a top 50 up and coming lawyers in 2023. Karibu Milap.
Thank you. Thank you, Naileen, for that introduction. Thank you.
Thank you so much for agreeing to join us, for sharing your knowledge and your experience. We are confident that we are in safe hands. So, to the audience, our Milap's request is you send through your questions and she's going to address them towards the end after she does speak to us and we have the knowledge transfer session. So, Milap, over to you.
Thank you. Thank you very much. So, briefly, we will be going through an overview of the legal regime that governs employment in Kenya. I know everyone is affected by employment one way or another. If, as an entrepreneur, you're concerned about employment because you're employing people, as an employee, you're also concerned because you are working as an employee. So, I think this is something that cuts across different people, regardless of which position we're in. And so, we'll just be going through generally what the law provides. So in my next slide, on labor law under Article 41, which says everyone has a right to fair labor practices. And fair labor practices include fair remuneration, as well as the right to join a trade union and to go on strike. You would be surprised, when you recently we saw that the doctors were on strike. The right to go on strike is a protected constitutional right. However, on a day-to-day basis, so the nitty-gritties of the employment relationship are more
Hi, we got kicked off.
I
Oh,
had lost my connection, sorry.
okay, no worries, no worries. Let's just reconnect.
Yeah.
Sorry, very sorry for the technical issue. Let's proceed.
Yes. So I was saying the nitty-gritties of day-to-day employment are more are covered in more detail in the Employment Act. This is an act that came into force in 2007 and has seen a lot of litigation, a lot of interpretation by the courts since then. And then finally, there's the Labor Relations Act, which has the details on formation of trade unions. Primarily, that's what it deals with. And we have very many trade unions in the country. Examples are BIFU for those in the banking and insurance industry. We have KUDEA for those in the hotel industry, for example. And then I've included KPMG, the medical workers union, because recently they were on strike. So that's something that was recently in the news. In the next slide, you will see we will look at the employment relationship, and we'll start with what are the obligations of the employer. Why I've done it like this is because the law views the employment relationship from an employer employee perspective, in that in most cases, the employer has the upper hand, and therefore, in order to level the bargaining field or the bargaining power of the parties, a lot of obligations are placed on the employer. This act came into force after it was realized that there's no legal regime really protecting employees. And previously, employment was essentially left to the caprice of the employer, so that, you are technically employed at the pleasure of your employer, as opposed to now under the act and the constitution and the decisions emanating from the law. That is no longer the case. There's a lot of legal protections, and these legal protections, one of the way the law does this is by imposing certain obligations on the employer. And what are these obligations? So for example, the law requires an employer to provide a written contract of employment. So this means that, even if somebody engages you and, we agree terms orally, there is a legal obligation to put those terms in writing. And what are some of these terms? These include the place of work. So a contract has to tell you you will be employed, for example, working in Thika town. Your hours of work. This is important. It has to stay when work starts and work ends. Normally, a work day is 8 hours a day, so 8 to 5 or 9 to 6. And these hours must be inclusive of at least 1 hour lunch of a 1 hour lunch break. And these are important things. Like place of work, people will take for granted, but for example, the employment court has held that if my contract of employment says I need to work in a certain place, so let's use Thika as an example, transferring me might be a breach of my contract if there is no transfer clause in the contract or in the policies of the company, so that I am entitled to be employed in the place that we have agreed to. So things like place of employment are critical. Hours of employment are also critical, especially for people who are in unionizable roles and could be subject to overtime. So things like how many hours I need to work are also important. Other things that are spelt out, day to day things, are things like leave policies, or leave entitlements. Who your supervisor is, who do you report to, what is your job description. I've seen contracts include, even your KPIs. So these are things that are important and create certainty. Um, the terms of the Employment Act will be implied in a contract of employment. Whether it's written or not, the terms of the Employment Act will be implied. This means that whatever the Employment Act gives as a right will be treated as minimum, whether or not it is there. The things that the Employment Act gives people right to. So, for example, and we'll see them in the next slide, some of these things, like a right to be on leave for at least 21 days in a year, will be there whether or not the contract says it. It will be implied. It will be implied in those contracts. They will also be implied if it's oral. So even if you don't have a written contract of employment, the basic minimums that the law gives will still be, an employee is still entitled to that. And so it is important for an employer to know this. This is an obligation, and you'd rather record that obligation from the outset. Another obligation that is mandated by law is to provide a written statement of pay. This is normally in day-to-day language, we call this a pay slip. In the pay slip, I have to show what is my gross salary, what are the deductions to my salary, and in part of that, the deductions are statutory, so NHIF and NSSF, of course, and payee. And then for example, institutions where there is a facility made available to an employee. So let's say I've taken a loan that I am servicing through my salary, that deduction has to show there. Or maybe I'm contributing to a SACCO, that deduction has to be set out. This is important because there has been litigation where, for example, because of lack of a pay statement showing that somebody was paying an SSF, then they become entitled to claim what we call service pay. So if you're not deducting an SSF, then you could be entitled to service pay. Um, these obligations apply regardless of the type of employment. So, for example, just because I am on a fixed term contract that is expiring after a certain period of time doesn't mean I don't have a right to these obligations. So that it's not only for permanent and pensionable employees, it is for all employees. There could be additional expanded obligations depending on the contract between the parties. So parties might agree, an employer and an employee may agree to, let's say, instead of 21 leave days in a year, 25 or 30 days. Instead of, 7 leave days in a year, they could agree to 10, 20, 30. This is also particularly in cases where employees are unionized. And so negotiation is based on a collective bargaining agreement where expanded benefits are negotiated. So that what I've set out here are minimums, however, they can be expanded depending on what the parties agree amongst themselves. And so in my next slide, I have set out rights of the employee. So we're still talking about the relationship between employer and employee, but now this time we're talking about the rights. As I say, the law generally tends to view employers as having the upper bargaining hand. This is generally because, for example, look at the level of unemployment in our country and the need to protect employment as a source of livelihood. But these entitlements that I've set here are the basic minimums. So one entitlement in the law is that every employee is entitled to 1 day of rest in every week. So for every 7 days, there's 1 day of paid rest. So as an example, Monday to Sunday, if you work Monday to Saturday, you're entitled to rest on Sunday and be paid, right? For institutionalized employees, most people work Monday to Friday, but still get a monthly salary, which includes Saturday and Sunday. So this is what it means. Then there's 21 days of paid leave for every 12 consecutive months. So essentially, for every year, a minimum of 21 days leave. Practice now is that these days are being prorated so that, for every, it comes down to about 1.75 in a month. Female employees are entitled to 3 months paid maternity leave, and male employees are entitled to 14 days paternity leave. The courts have held that for female employees, if you go on maternity leave, you're entitled to go back to the position you were in before maternity, which means then you should not be demoted while on maternity leave, or you cannot be terminated because of going to maternity leave. So maternity leave has been litigated on, and the courts have protected it in that sense, so that an employee on maternity leave is entitled to go back to their role and to go back, to the same pay, not to be demoted, not be terminated by virtue of maternity leave. Then the law was amended in, I want to say, around 2020 to allow for adoptive leave. This means that, for parents who are adopting children, they're also entitled to 1 month paid an adoptive leave. And this one doesn't say male or female, it just say adoptive parent. So whoever is adopting a child is entitled to 1 month leave, paid leave. And then there is 7 days paid sick leave. And this 7 days is annually. So for every year, you're entitled to 7 days paid sick leave. However, the law also says subject to some sort of medical certificate, a note, essentially a doctor's note. And in practice, for every 2 days, so one day is fine, but for any sick leave beyond 2 days, a medical report of your incapacity is required. Again, as I said, these entitlements may be expanded. It is not uncommon to see, I have seen people with agreements giving them 30 days of sick leave. I've seen, 35 days of annual leave. So it can be expanded, but what I've set out here is the basic minimums that the law guarantees. Now, in the next slide, you will see. Yes. So in the next slide, so we've seen what the employer-employee relationship is. We've seen what the obligations of the employer are and what the rights of the employee are. Now, the bone of contention in employment relationships, and if you look at, the bulk of, I want to say 99 to 99% of the litigation in employment is regarding termination. So termination of employment becomes, a sticky issue because, as I say, unemployment is a problem in this country, and also employment is a source of livelihood for very many people. So it becomes a sticky issue, and this is one of the most litigated topics within the bigger umbrella of employment in Kenya. The employment relationship can be terminated by the employee. The employee has a right to terminate the employment relationship essentially by resigning. So by giving notice of resignation. Notice should correspond with the period of payment under the law, so that if I am paid on a monthly basis, my notice then has to be at the very least 1 month. So that if salary comes in every month, my notice cannot be less than 1 month. And so it's usually contractual. Most contracts will say 1 month, but some contracts have 2 or 3, depending on the level of seniority or the nature of work that is being undertaken. But in normal circumstances, it tends to be a month because that is also the frequency within which payment is made. So for an employee, all they can do, they can terminate through resigning. Basically, that is giving notice. Now, for an employer, it is not that straightforward. An employer cannot simply give notice. I know there are many contracts that say either party may terminate by giving notice, but it's not that simple for an employer. There are certain procedures set out in the Act, and these are set out in Section 41 of the Employment Act. And one of the requirements is, one, an employer must give what we call a notice to show cause. In the notice to show cause, the employer must set out in detail the reasons they are considering termination. And these reasons have to be valid. It cannot be, for example, that, I don't like the shape of your face. It has to be valid reasons related to the nature of employment. So a notice to show cause, setting out reasons, and giving the employee an opportunity to respond. Thereafter, then, sorry, one of the so for in terms, before I go to the next step, the reasons recognized by law are gross misconduct, which is very wide. There are very many things under gross misconduct. For example, theft, insubordination, being inebriated while at work, being suspected of a criminal offense. These are gross misconduct, but generally, that the list under Section 44 of the Employment Act is not exhaustive. And what the courts have said is that gross misconduct is conduct on the part of the employee showing that employment is no longer tenable. So that they're based on their conduct, they're telling the employer, I can no longer be employed by you because of how I am acting. So that's gross misconduct. Then there's poor performance. Incapacity then means, due to health issues, or usually health issues, someone is no longer able to carry out their duties. And then incompatibility means, generally people are just not getting along. It is impossible for them to work together. We've seen this litigated on, but on usually higher level employees, executive level people who need to sit down and make decisions together, so that if they're incompatible, then it becomes impossible to do that. Once a notice to show cause is issued, the employee should be given a chance to respond, usually in writing, so that I've been given reasons in writing, I should be able to respond in writing. The period of response is also important because, natural justice, fairness in terms of how much time is given. And by that, it's court, this point has been litigated so that someone cannot be given a notice to show cause in the morning and be expected to respond by close of business. The courts have said reasonable amount of time should be given. There is no measure, but it cannot be the same day at the very least. It cannot be the same day. And then after that, depending on the explanation given by the employee, if it is not satisfactory to the employer, then a disciplinary hearing. A disciplinary hearing can be held, and before it is held, a written invitation to the disciplinary hearing should be sent. In the invitation, it should set out the date, time, venue of the disciplinary hearing, and it should also notify the employee of their right to be accompanied by another employee of their choice, and if they are a member of their union, by a shop floor representative. That information is critical. It is a legal right. If it is excluded, it can then floor the entire process. So the fact that someone is entitled to be accompanied by someone else should be made known to them in writing during the invitation to the disciplinary hearing. Then at the hearing, of course, it is a chance to have an oral discussion about what is happening. And, in a fair process, the employee should be given a chance to explain themselves in their own words. Thereafter, then, the employer takes time to consider the representations made during the disciplinary hearing. And if they're still not satisfied, if it is still, even after we've done all these things, it is the employer is of the view that it's still necessary to terminate the employment, then they must issue a termination letter with the reasons for the termination. And, we must set out, why we got to this position. However, these must be linked to that first letter which we issued, which we call the notice to show cause. So that I cannot, in my notice to show cause, I cannot give you reason A for termination, but in the termination letter, I'm setting out reasons B, C, and D. So the reasons must be incongruous with the notice to show cause. So this whole process, all the things we are discussing must flow from the notice to show cause, so that I cannot bring in other things in the course of the process, because maybe I felt you explained yourself sufficiently and now I am coming up with a new reason. They have to be a thread must be pulled from the beginning to the end. And then in the once I set out the reasons, again, you have to set out what we call final dues. Final dues essentially are, this what this person is entitled to be paid as of their last day, and this includes salary up to the last day that they work, any accrued but unspent leave, and any other thing. So in by other things, I would say things like bonuses in some contracts, depending on how they're drafted. Someone may have earned a bonus at that point; they should be paid. It really depends on the nature of the contract, but as a minimum, salary up to their last day and any accrued but unspent leave. As I said, this is one of the most litigated areas on employment law, and failure to follow these processes, the courts have said failure to strictly adhere to this process, they're now, it's what I like calling strict liability. The process creates strict liability, so that if you don't follow it to the letter, if it is not seen that a fair process was followed, then employment determination will be deemed as unfair, and the employee could be entitled to a maximum of 12 months salary as compensation if they're successful in litigation. And so, going to my next slide, flowing from that is employment disputes. As I say, these disputes come from, especially from termination, a lot of disputes arise. And so when a dispute arises, they go to court. Initially, exclusively, the disputes would go to the Employment and Labor Relations Court, which is a court with equal status as the High Court. However, due to the volume of work and the nature of the cases that were coming in, this was subsequently devolved, and so some claims based on their monetary value go to when I say subordinate, I mean magistrates court. So they'll go to the magistrates court. So the magistrates court now have power to determine certain employment claims up to a certain value, and then beyond that, or appeals from that, then go to the Employment and Labor Relations Court. Disputes can also be referred to the Labour Office for evaluation and resolution. The Labour Office is, a part of the Ministry of Labour, and they have a Directorate of Employment which deals with such matters. They can make, they have power to, for example, investigate, come to an employer, seek employment records, and investigate and come up with a report. Even though they do not have powers to sanction or to enforce, that report, a report from the Labour Office, is certainly persuasive should the matter go to court. It's certainly persuasive to the court. In evaluating employment disputes, the Employment and Labour Relations Court and even the Court of Appeal, all the way to the Supreme Court, have held that there has to be both procedural and substantive fairness. By procedural fairness, I mean the steps that we've looked at. An employer must follow all those steps, so that skipping any one of those steps or not allowing an employee the opportunity to be heard throughout these steps then makes the process unfair. Substantively, fairness means that reasons for termination must be valid. They cannot be, and sometimes it's clear that, there's no valid reason here. Sometimes an employer will follow the steps to the letter, but when we look behind the process, we see there's really no reason for this, or the reason that has been put forth is not supported by any evidence. And therefore, that then creates substantive unfairness. In employment law, and even in the Act, I think this is in section 45, the burden of proving fairness of termination or validity of the reasons for termination rests on the employer. So that an employee makes a claim of unfair termination, then the employer has to disprove that claim. The burden then shifts to them to prove that it was actually fair. As I said, the maximum award is 12 months, the equivalent of 12 months salary. However, this does not include damages. Usually, we are seeing an increase in claims of discrimination, where, under the Constitution, there are certain rights protected, including fair labor practices. And so that, people are making claims. In addition to unfair termination, there's claims, constitutional claims, of discrimination, of unfair labor practices, and other constitutional claims, where damages can be given based on the discretion of the court. There is no limit. So it depends on the case, on the extent of the unfairness, and generally, the evidence placed before the court to award those damages, in addition to compensation for unfair termination. Yes. So I think that gives us an overview of employment law from institution to termination, and in the event of disputes, what happens. So from here, I think now we can maybe engage with questions.
Alrighty, thank you. Thank you so much, Mila, for taking us through the slides and educating us. I've learned quite a bit from it. I'll stop sharing and start posing the sharing the questions that have come through. You'll see them at the bottom of the screen. And if we are to start at the very top of what you started speaking on a contract should be written. In the event that a person that let me just read it out. If you don't have a contract, how do you prove that you had been hired?
All
You
right.
have
Now,
nothing written, and
mm, I would say this. One, the law, not the court, the law places an obligation to keep records on the employer, right? If let's say I don't have a contract, what I can say is I was being paid every week, every 2 weeks, every month, and I can show how I was being paid. Even if it's cash, I can say I used to receive cash from this person every so often. So I used to come here, I did this kind of work, and I used to be paid this amount. And once I say that, then the burden shifts to the employer to disprove that, to disprove that I wasn't working for them. And then they would be asked, then why were you paying this person on a monthly basis, for example? But at the very least, the fact that some sort of payment was coming in on at a certain
hmm,
regular interval can be the basis of saying I was employed by this person.
hmm.
Yeah.
Okay. So I think when I'm even thinking about it on the point of view of the people we have hired in our homes, the nannies, the housekeepers, the garden people, the pool maintenance team.
Mm.
It's even as far as complying to the law is concerned, not just as us as the employers, but also from the employees or but also from the employer. Our
And
next
yes,
question,
sorry,
just from the
sorry,
very top
Nolene.
on, have I lost connection?
Yeah, I'd lost you. Yes,
Can you hear me?
yes, we've lost you, Nolene. Can you hear us? Sorry.
Hello.
Yes, I I think I can take this one because I can see the question on the screen.
Hi, Mila. Sorry.
Now you're back. So yes, I was saying I could take the question because I can see it on the screen. And it reads, what happens in situations where it becomes common practice to be expected to work past the 8 hours without overtime? Now, overtime, and in relation to hours of work, is dictated by law for a certain cadre of employees, so that for people earning what is considered as minimum wage in different sectors. And minimum wage is not standard. It's not a standard minimum wage for everyone, but for people under minimum wage in certain sectors, or people who are unionized, then the union has, under the collective bargaining agreement, then there is directives on overtime. But outside that, so that if somebody is earning a salary that is considered managerial level, it's not minimum wage and it's not subject to a collective bargaining agreement and can be considered as managerial level salary, sometimes it can be expected or required of them because of their high level of compensation to work outside, you know, the usual 8 to 5 without additional overtime. So yes, so it can be common that because of the nature of the salary being considered as managerial, so that if you're a manager and you're being compensated as such, and I don't mean manager by title, I just mean that by virtue of the salary you're receiving, then it can be necessary to work beyond certain hours. Noeline is rejoining us shortly so that we can take the next question.
Okay.
Okay, I've seen the next question is, what does the law say about probation and then declared redundant? I think I'll take probation first. So probation, the law provides that it cannot be for a period exceeding 12 months. So that it cannot, no, someone can't be put on probation, for example, for 13 or 15 or 18 months, a maximum of 12 months. Because the justification for this is that within 12 months, you should be able to tell whether you want to work with this person or not. In common practice, it is usually 3 to 6 months, subject to extension, but within the 3 to 6 months, usually a decision is made on whether or not probation is gone through it successfully or not. um, and then declared redundant. So I'm taking this question to mean someone is on probation redundant. Now, redundancy is end of termination without due to circumstances beyond the control of the employer and not by the fault of the employee. So the employee hasn't done anything and the employer is forced by circumstances beyond their control, sometimes economic circumstances, so that their business is just not economically viable. Sometimes things like the pandemic, we saw a lot of people being declared redundant because the pandemic made it impossible for those businesses to continue operating and then generating the revenue to pay their employees.
Wow.
Yeah, sometimes it can be regulatory issues. So redundancy is termination of employment due to factors beyond the control of the employer and not due to the fault of the employee. So it could happen that, for example, the pandemic is happening while someone is on probation. What do we do about that? So it's not that because you're on probation you're exempt. It could be that the business has, for whatever reasons, has made it necessary to declare people redundant, and therefore they have to go through that process. That said, redundancy in itself has its own legal process, beyond what we've discussed about termination. And this legal process includes in notifying the labor office and conducting consultative meetings with all affected employees, explaining the reasons for the redundancy and why these people are affected by it. And at the end of it, then there's certain payments that employees need to receive, including service pay for those employed for at least a year.
Okay, thanks, Mila, for the feedback. Apologies, I'm having technical issues, but we will proceed. So the next question that was asked was, What are my rights to join a staff association or union and the employer does not want the individual to join the union?
So as I said, the right to join a union is protected in the constitution, number one. And number two, employers under the Labor Institutions Act, as long as 50% plus one of employees want to join a union, an employer must recognize it. So an employer, let's say with 100 employees and 51 want to form a union, the law mandates the employer to recognize that union and engage with them from a union perspective, so that in terms of negotiations, it will no longer be individual negotiations with employee, it will be through the collective bargaining agreement. So as long as there is a union in place and 50% plus one of employees want to join, then the law mandates recognition. There isn't the law doesn't give employers an option on that.
Okay, so if you're in a situation where you want to do it and your employer does not want you to join a union, how
I
do you
would
go about it without risking your own job?
I would say maybe speak to the union reps, and then they can find a way to, because a lot of these negotiations are done through the union reps. I would say speak to them and they can then start the conversation, because if it exists already, they already have channels of discussions with the employer. I would say speak to the union reps and then see how they can get you joined up, and that way the pressure will not be coming from the individual, it will be coming from the union.
What happens in the event that, just speaking from what you said, in the event
Mm,
that the organization does not have a union and the
yeah.
organization does not want its employees to form or join an existing union, even if the union is not within the organization?
So for that one, I think we used to see a lot of litigation on that point, so that, collectively the employees would join either themselves or now asking that union on their behalf to bring a claim against that particular employee, so that the union that they want to join, so let's say for example it's a union of um, mechanical workers, for example, and the mechanical workers in the company doesn't want these mechanical workers to join a particular union, they can go to the union they want to join and then get that union to essentially sue or report the employer to the labor office, so that any legal action is being taken by the union on behalf of the prospective members. And so the union will be saying, we are compelling the employer to recognize either through the labor office or through court, to recognize these people as being entitled to join and to let them join.
Right. Thank you. Thank you for shedding light on that. So the next question that has been asked is, I think what this person is trying to ask is, what is the difference between being terminated versus
Mm.
being declared redundant?
So termination is a disciplinary measure in the ordinary course of business, in that an employer, for whatever reason, gross misconduct, poor performance, incapacity, decides to end the employment relationship. So termination is ending the employment relationship by the employer for whatever reason, right? Redundancy, as I say, is end of employment as a result of circumstances beyond the control of the employer. So that, for example, it's economic reasons, they're just not making money. It could be the pandemic, it could be whatever reason it is beyond their control, or it's something they can't do anything about right now. And it is not due to any fault of the employee. So the employee hasn't done anything wrong at all. There's no fault. And the employer is unable to prevent this particular situation due to extraneous circumstances beyond their control. Usually, this tends to affect the revenue of the business so that they are no longer able to do it. But sometimes outside of revenue, it can be restructuring of the business so that this role is no longer necessary. Or for example, laws have passed that affect, let's say in regulated industries, a law is passed that affects this particular role or makes it no longer necessary or something like that, so that it's something beyond, it's not a decision that has just been made. An extraneous factor has come in to force this decision.
Okay, okay, and understood on this much. So the next question being asked is, I'll just read it directly as it has been asked. So the
Mm.
person is asking, if I have worked for 3 years at a place and I opt to resign, am I entitled to severance pay or service pay?
Now, for service pay, according to the Employment Act, service pay is only payable if you are not contributing to NSSF, because these both service pay and NSSF are seen as something to help you when employment ends in the long term. So maybe a contribution to social security, essentially retirement. They're seen as being at the same level. If you contribute to NSSF, then you're not automatically entitled to service pay unless there is a provision in your contract to that effect. So unless your contract says regardless you will receive service pay. If your contract doesn't have that and you are a contributing member of NSSF, then service pay is not payable. Severance pay, and sometimes people use these things interchangeably, but we've seen the employment court say severance can be gratuitous, meaning I am giving it, an employer is giving it out of their own discretion. So that one is discretionary and it's not dictated by law. So that if like previously, I know old language people used to use something called the golden handshake. So that if an employer wants to give you that, no problem, but it is discretionary. It's not mandated by law. It's up to them. But service pay and NSSF are mutually exclusive, subject to the terms of a particular contract.
Okay, I think that answers that. On
Mm,
the next question, what rights as an employee do you have to reject a location change by your employer? Can
mm,
you legally protect yourself in the event they decide to get aggressive and say to you, you go or you go?
mm. Now, location change, as I say, you remember we were talking about written contracts and place of work. So sometimes a contract will say you will be employed, let's say, in Kilgoris. However, the employer has a right to transfer you subject to the exigencies of the business. So that the employer has maybe 24 other locations in the country, but when you are initially being employed, you are employed in Kilgoris. If the contract says the employer has a right to transfer you, subject to the exigencies of work, then you agreed to that. You signed that contract. You then can't come down. When we are getting the job, sometimes we don't look at the nitty gritties of these things. But if I signed it and I didn't ask, for example, for mine to say Kilgoris exclusively, if the employer then wants to move me, let's say, for example, to Mombasa, I agreed. I agreed because my contract says I'll be based here, but my employer has a right to move me based on the exigencies of their business. So if it says that, it can be in the contract, it can be in a staff policy, but there could be something giving an employer discretion to do that. Now, can you legally protect yourself? And by this, I mean, can you refuse? That one, I would say, as I say, employment is a relationship. If an employer is asking you something and you refuse, it could have an impact on the continued relationship, because it's not just work. fundamentally there is work and pay, but there's also an issue of the relationship. So if there is room to negotiate or explain or seek alternative um, an alternative solution, for example, and by alternative solution I mean a relocation allowance, or can I work remotely, can to try and find something around that, because then if it means refusing and that could jeopardize your work, then that's an issue. So for this question, I would say first look at your contract, including the policies. Did you agree to this? If you did, then you essentially are you are bound by the terms of your contract. If not, is there room for negotiation in a mutually beneficial way, or at least room to meet in the middle somewhere? Yeah.
Mm, okay.
Mm, mm,
I think you have answered elaborately, and
mm.
I suppose the person who submitted this question could also reach out to you for a consult if they want to shed more light on the
Yeah.
situation, since
Yeah.
this is the breadth of information they have shared.
Mm,
Another question that has been asked, I'm seeing it from the LinkedIn platform, is there any exposure from terminating an employee who is insubordinate, who insubordinates his supervisor and uses inappropriate language?
Insubordination is a ground for termination. It's actually spelled out in Section 44 of the Employment Act. So definitely it's a ground. That said, one, as we said, the process for the termination must be followed to the letter. So that just because someone, was insubordinate or abused someone, doesn't mean we wake up and tell them get out immediately. We must follow the process. Number two, the as I said, the burden of proof rests on the employer. So that when I'm saying you are insubordinate, I need to set out in great detail what I mean by that. And by that, I would say, on Monday, you came in at this time, you were given this instruction, you refused to carry out the instruction.
Mm,
Um, in as much detail as possible. So, yes, it is a ground for termination, but it doesn't excuse the need for both procedural and substantive fairness.
okay, okay. I think the gentleman is now answered. We are running out of time, and there's so many. Mila, please allow me just a little more time to ask some of the questions that are still coming through. So
Mm,
this is a two-part question because of the character limitation that we have on this platform. And the
mm,
question is, if your employer wants to separate from you, that is, perhaps management of the day does not like you, but they are telling you to resign rather than retrenching you, or they say your position has become redundant, yet they
mm.
have already hired your replacement or already have your replacement in mind. Is there a law that protects the employee in this case, e.g., requiring the employer to pay you X months as part of the separation? I think they've put in multiple issues, but please just respond. Let me load the first part for you to read through again, then I'll load the second part for you again.
So, again, there's been litigation on the point of someone being told resign, and an employer, a resignation has to be voluntary. If I am resigning because I have been told to, that's not a voluntary resignation, and litigation on that point has said amounts to what we call constructive dismissal. So that if the reason I write a resignation letter is because I was told and I have evidence of this, then that amounts to constructive dismissal. Retrenchment and redundancy, I think that they mean the same thing. Redundancy has a process. Part of that process, as I said earlier, includes notifying the labor office and engaging in substantive consultations with the employee for a certain period of time. And at the end of that, if redundancy is still necessary, paying out redundancy dues, which includes service pay for every complete year worked. So if the position is redundant, then a process must be followed. It can't just be redundant. There is a process that must be followed to the letter. Otherwise, again, there is basis for claiming unfair redundancy. On to the next second part of the question, where they were asking about, is there a law that requires to pay X months? I think here this person is referring to mutual separation. So sometimes it can be, yeah, the management of the day doesn't like you. It is made known to you that, this is not working. Let's part ways mutually. You can part ways mutually. However, this is a contract again. The same way we negotiated the employment contract is the same way we will negotiate the mutual separation. And it must have all the elements of contract, including, capacity, ability to sign. I mean capacity and consideration, so that offer, acceptance, consideration. I must get something out of this contract. That something, X months, is now subject to negotiation. It's subject to the negotiation between the parties. The law will not imply the terms of the contract for you here. So if you can reach an agreement to mutually separate, subject to certain payment, well and good. But there isn't
Okay. All
a
right.
dictated minimum. Yeah.
Okay. I think there is another angle that this person is asking about, because they say that they're being
Mm,
asked to resign, yet there's
mm,
already a preferred candidate or a replacement. Somebody is already being propped for the
yeah.
role. So,
Yeah.
in such a situation, what protects the employee?
Unfortunately, again, so this falls in the same category as being forced to resign. If I am working as, let's say, officer level A, and officer level A can only do a certain job description, like in this organization, having that title means this is the only job I can do. Then tomorrow, and I know we are in the background, we are having these kinds of conversation. Then tomorrow, I see somebody else, officer level A. Essentially, you're telling me either it's the two of us are doing this job or one of us is leaving, and I'm the one who's been told to leave. That also amounts to constructive dismissal. So, in terms of protection, uh, it doesn't stop them from doing it, but it gives you a basis for claiming constructive dismissal. which is
Okay.
which and constructive dismissal is technically unfair termination, which and you would be entitled to up to 12 months salary as compensation, obviously now subject to the court process.
Okay.
Yeah.
Understood. Thank you. Thank you, Milap. There is there another one? Yes, there is. There's a question on overtime, and they're asking on the overtime question, what
Mm,
if you're earning minimum wage?
mm. Yes, we had dealt with overtime earlier. And what I was saying is that, it tends to apply for people in who earn minimum wage, because even the minimum wage order sets out overtime for different categories of employees or people under a collective bargaining agreement. So you tend to find in these kinds of documents they set out overtime. If you are earning minimum wage, it depends on the category, because it varies from different job sectors, but it sets out what overtime should be. And it's usually one and a half of your hourly rate for working overtime. That is especially on weekends, and then sometimes it can be half. Yeah, it tends to be one and a half or double for Sundays and public holidays. But it depends on the category. So I wouldn't tell you this is how much you should be paid. It depends on which category, because it has, let's say, certain workers, drivers. It really, artisans. It defines different categories of work and then calculates it differently depending on the nature of work. Yeah.
Mm.
Mm.
Now, Milap, just to expand a bit on this, I've seen
Yeah.
contracts that read that you are being hired into management. Management does not qualify for overtime. Then there's an
Mm.
additional clause that's put in that reads, you may be called out from time to time to work over and above your usual hours. And this could
Mm.
include you have been hired Monday to Friday 8 to 5, But this
Mm,
clause now allows the employer to call you into work past 5 p.m., expecting you
mm,
to work past 5 p.m., or
mm,
expecting you to work during public holidays, or expecting you to work additionally on Saturday. What
mm,
is the protection in such a case for the quote unquote management level
mm, mm,
employee? When this person can, for example, count even upwards of 20 hours in a month of overtime, but they are not
mm.
qualified by virtue of their contract to get overtime.
Yeah. Now, management doesn't necessarily even mean that you have the level, the title manager. It just means by virtue of the salary you're getting, according to the employer, you're properly compensated and may be required to work outside the normal 8 to 5 Monday, Friday. So
Mm-hmm.
it tends to be there. It tends to be there. And, exigencies of work may require that somebody works outside the normal working hours from time to time. That said, as you from what I can understand from you, some people abuse this so that it then becomes a basis for saying you must work till 9 p.m. every day, you must come in on Saturday. For me, in those situations, I would say, if possible, try to renegotiate terms so that you thought you were signing on for occasional extra hours, and now it seems it's the norm. If you're able, try to renegotiate terms to get expanded compensation. If that's not possible, expanded leave, just to renegotiate something so that you're also getting something back if possible. But otherwise, there's really no, I wouldn't say that the minimum wage order and the requirements of overtime apply there, because if the salary is beyond what is set out in that order, then those terms of extra compensation, such as the 1.5 for every extra hour worked, wouldn't apply for certain salary scales. So the law is not protective in that sense. I would say try to renegotiate, and then if it's not possible to renegotiate, then it's either a decision is taken in terms of, do I leave this job and find another one? If I am forced to resign due to what I want to call very unfair um, or inconducive work environment, that can be a basis for constructive dismissal. That said, not everything is constructive dismissal. I think we have to be careful and show that in a circumstance like this, attempts have been made to rectify or to complain, to try and change the issue, and nothing has been done. So that I am being pushed to this position because I've done everything I possibly can to change the situation, but nothing is changing. I can see, I don't know if we've lost Noeline, but
Sorry.
I can.
Oh, sorry. I was going on and on. So I was saying it's interesting that you've raised the issue that not everything is constructive dismissal, because one of
Mm,
the audience has asked, on constructive dismissal, when does it apply in Kenya?
yeah, yeah. I wouldn't tell you there's a list, but what I'll tell you is constructive dismissal is where an employee is forced to resign due to the employer creating an environment that makes it untenable for the employee to remain. So that you remember, I think this would be the opposite of gross misconduct. So that gross misconduct is an employee's conduct making it untenable for them to continue being employed. On the other side of this is my employer is making the environment in which I work so unbearable, I can no longer stay there. And this can be very many things. It can be, abuse, harassment, bullying, being told to resign, someone else being hired to do my job, being asked to work unreasonably long hours consistently without any extra compensation despite requests not to. So it really depends. It moves from, it varies with the circumstances of the case, but as a general test or measure, I would say it's conduct by an employer that makes employment no longer tenable.
Thank you. Thank you for sharing that. We are past time. I've heard bit of network issue, but thank you so much, Milap. You have been an extremely gracious guest. Thank you so, so much. May I please request for a few more minutes of your time just to go through this list of questions and to just confirm we've responded to all of them. I think we did respond to what does the law say about probation and then being declared redundant. Yes,
Yes,
we
yes,
did. What
yes.
are my rights to join a staff union? We did respond to this.
Mm,
The difference between being terminated and being declared your role, not the individual, the role being
yes.
terminated and the role being declared redundant.
Yeah.
The question on entitlement to severance pay or service pay,
Mm,
I've understood
mm.
that NSSF and service pay are mutually exclusive. They cannot coexist. The existence of
Unless
one
and
automatically.
yeah, subject to a contract. You know, some people will say you'll still get an SSF, but we will still give you service pay. So unless there's
Oh,
a contract to that effect, then they
mm,
become mutually exclusive.
okay, all right.
Yeah. Mm.
Um, on location change, I think you have explained, you have answered on this. Just look at the fine print of your contract.
Mm.
On if employer wants to separate, I think this is the question on constructive dismissal being done in a very, I will call it shady, because that's the correct word, shady way. Uh, if you don't have a contract, how do you prove you've been hired? You did answer this as the first one. What happens in situations where it becomes common practice to be expected to work past the 8 hours without overtime? Did we
Mm.
respond to this?
Yes, yes. I think when we were discussing this, we had lost you, but we had
Oh,
a discussion on this.
oh, I'm so sorry about that. Okay. Is there any exposure for terminating insubordination? You said this is one of the very well defined grounds for
Mm.
termination.
Mm.
On overtime, on minimum wage, you responded to this. The parameters also. I don't know if we'd answered this. Can you terminate a contract of employment where the employee is on a performance improvement plan but has begun to absent themselves without cause and the PIP period is still ongoing?
Now, this is a difficult one. It's interesting. However, so
Mhm.
PIP is a performance management tool. It shouldn't be seen as a punishment. It's a performance management. And the courts have said, during this period, the employer must show that they are doing what as much as possible. They're giving as much assistance as possible to the affected employee to improve. So that it's let's work together to see how we can improve your performance. That said, being absent from work without permission, without leave, is another ground for gross misconduct spelled out in the Act. So this is one of the grounds for termination of employment. And certainly, if someone is not, being coming to work without permission, that's a ground for unfair termination. So that the PIP aside, this issue has now arisen and is a basis for terminating employment. That said, so I think I have to repeat this. That said, even if someone has done this, does not excuse the employer from following the procedure in the law and from allowing a fair process to be followed to the end. So that it's not now we are piling, we're saying you're even on PIP, now you're doing this, just get out. No, no, no. There's no reason that excuses the need to follow the fair process that the law requires. So the PIP aside, being away from work without permission under the Employment Act is grounds for unfair termination on the basis of gross misconduct.
Okay, already.
Mhm.
Two more have come in. Do you have time, Milap, to answer the last two?
Yes.
Okay.
Mm.
Um, does the Kenyan law protect its citizens from foreign companies operating within the country?
So I think but this person means, like what if the employer is not a Kenyan entity? Usually what tends to happen is that, it's a global brand, but probably has a local subsidiary. By local subsidiary, I mean a Kenyan registered company. So that in as much as the brand is global,
Mm,
the company actually signing the documents is a Kenyan company. So sometimes employees will see, I'm working under this brand and all that, and assume I'm employed by a foreigner. But the practice tends to be the international brand will probably register a local Kenyan company to sign the actual individual contracts. In the absence of that, a foreign company wanting to employ Kenyans there's a procedure set out in the Employment Act. There's a bond that has to be given to the government so that in the event of, let's say, unfair termination claims and things like that, there's a way to compensate the employees. So it's a very uh, I want to say, regulated process. For a foreign entity to come and employ Kenyans directly, they must deal with the government first and give the bond a certain amount of money as bond to say, we will run our affairs properly, we will follow the laws of the country. Yeah. So in terms of whether does the Employment Act apply, absolutely, it will apply.
it will still apply.
Yeah.
Okay. One more. Actually, they are increasing with the time being kaput. What happens where the employer terminates your contract, e.g., in a restructuring, but then you are forced to resign? This sounds like double jeopardy to me.
Mm. I would say, first of all, if my employment has been terminated, so step one is someone has terminated me. What am I resigning from if I've already
Mm,
been terminated? There's nothing to resign from if I've been terminated. So if there is a termination on record, there's no need for a resignation. That to me sounds like something is off. And even if let's say as an employee, I don't have a choice and I'm made to sign that document, it doesn't take away your right to claim unfair termination in the future. Because if you can show these things happened after each other in the chronology of events, the
mm,
resignation came after the termination, it means nothing because I can't resign from a job I don't have.
that is
So it
true.
doesn't take yeah, it doesn't take away your right to still, pursue a claim.
Okay, thank you. There are a lot of questions. When I read through I think there's a theme, a carrying theme about unfair termination in different ways. Are you picking that up, Milap, or am I on my? I don't know if I'm really
I
getting it correctly. What do you think?
Yeah, I think so. I think so. It tends to be, as I said, it is the most litigated area of employment because
Mm,
at the end of the day, it's the end of someone's livelihood. So this is something that has been litigated all the way to the Supreme Court.
wow.
Um, what I can say is, we can maybe look at the questions, collate them. People can continue sending them to you, and we can plan a follow-up session to just address them.
I agree. I agree. Thank you so much, Milap, for being so gracious with the network issues and giving us an additional 16 minutes of your time. I feel like we've consulted with you. I don't even know how else to explain it. And thank you so, so much for
Thank
making
you.
the time, for sharing your knowledge and your experience, giving the recommendations you have given. And on your behalf, I will actually read out part of what you had written in your PowerPoint presentation, where you said that this does not constitute legal advice, and the speaker does not accept any liability for any reliance placed on the material in this presentation without express consent. I needed to make that call out. We appreciate the information that you have shared, but at the same time, we are saying if you want legal counsel, reach out to Mellap Wataka directly. You can refer to this recording for clearing of doubt, but for legal representation, reach out to her directly. Thank you so much, Mila, for your time. Thank you, everyone who's been able to join us for today's call and today's event. We appreciate it. We will work with Mellap's schedule and see when we can have the follow-up session to address the questions, the running theme on unfair termination, dismissal, and if I'm getting this correctly, some contracts and disciplinary policies. That said, thank you everyone. Have a wonderful balance of day, balance of evening. We'll see you next week. Bye everyone.
Thank you. Bye.
Bye.
Bye.